Welcome to Senior Aspects with your host, Ann Severs. Each week, Ann will talk about the issues that affect the 50 and older community. So grab a cocktail and hang out with Ann. After all, the kids aren't around anymore to spoil the fun.
Hello, my name is Ann Severs, and welcome to Senior Aspects. Today, welcome my guest, Blake Johnson, who is an estate planning attorney. Welcome, Blake, to our show.
Thank you, Ann. It's great to be here.
Thank you. So tell us exactly, what does a trust attorney do?
Well, the estate planning and trusts are kind of a wide area of law, so it encompasses a lot. It includes things like, your wills and power of attorneys. It also encompasses things like, your business, what's your business succession plan, how it's going to pass to other people, and kind of anything in that wide gamut. Also we do probate for people who don't have plans in place, so kind of stretches all over that.
So I was going to ask, let's start with that first, because that was the one thing I was going to ask. So why is it important for people to have, let's go back. What's the difference between a will and a trust? Let's start with that.
So a will is a letter to the judge that says, hey, judge, when you get this in probate court, this is what I want to have happen to with my estate when I pass away. And that's the traditional thing that everybody thinks of. Somebody passes away, you read the will, and that's what goes on. Well, just reading the will doesn't make it actually happen. That's where Hollywood doesn't get it right. You have to submit that to the court, and there's a number of administrative processes you have to go through, and then the judge will sign off and allow the assets to be distributed. It can take, in Vegas right now, it takes about a year to get done, at least, just because they're so behind on court dates. Versus a trust is a document that you put together. You make an agreement essentially with yourself saying, I'm going to put my assets into this trust, kind of like a business in the sense that it can own property and it does not die. And by putting it into the trust, we now avoid probate because there's nothing in your name when you die. It's all in the trust name. And so when you pass away, the trust already lays out who gets what, when they get it, who's in charge, and all of those things. And then all we need is a death certificate to get access to those accounts for who you leave in charge, and they can start dispersing it without having to get a court or a judge involved.
Okay, so on a will, even though you have a will, it will go to probate no matter what.
100%.
So which that occurs fees to the family.
Yep. I always tell people plan on 5% of your estate value minimum is going to go to attorney's fees and court costs.
Which is a lot.
It can be a lot, especially... just think about your house. If you have a house that's paid for that's $300,000, that's a big chunk of your house that has to go to pay the attorney when it's completely avoidable.
Yeah, it's like paying a real estate agent, right?
Well, I won't get into that argument.
So, I understand that a trust is something you put everything into, correct? So, like your home would go into it. What about like crypto and things like that? Because that's a big thing right now is cryptocurrency. What about that? How does that work?
Crypto's interesting. We're trying to figure out how to do the planning for it. The biggest problem is it's not something where you can list a beneficiary on or where you can easily change the account numbers, account owner on. So with, like, let's say you have a regular investment account, brokerage account. Well, there's a record keeper, and so you can go to them and say, hey, I want to change my account into my trust name, or they allow you to say who your beneficiary is. Hey, if I pass away, I want you to pay this account to X, or really what you should do is pay it into the trust. And so it can flow that way. With cryptocurrency, there's not a mechanism to do that. Now, as far as I know, I think Coinbase is working on something like that. They're one of the bigger wallets, so they may allow you to name a beneficiary. But as of right now, most of the wallets don't have that. That's one of the benefits of crypto is it's hidden. We don't know who the account numbers are or owners are. We don't know, or there's nobody regulating all of that. So the downside is there's no way to process that to the next generation if you should pass away. And so that's where you kind of have to do your own kind of essentially planning where you say, all right, if I die, here's where the account passwords are. Here's how you get access to it, and then trust that person will divide it the way you want. But it's a very interesting area as far as planning goes.
Well, it's going to be the future once it's regulated because it is coming. We invest a lot in crypto, but I do have like an iTrust account through iTrust. So I'm wondering, if I should go back in there, because I bet you I could make a beneficiary in my iTrust account.
Yeah, if you can, if they will allow you to name a beneficiary, that's what you would want to do, is name your trust as the beneficiary. That would be the easiest way. And it is, because there's a lot of development in there. There are more and more people or wallets allowing you to do that. It's still so new.
Yeah. We are creating a new currency as we speak right now with crypto. Since 1400s we haven't created one, so it definitely needs to be a conversation. And for an attorney to even have the open mind space to get into that field, I think is amazing, because a lot of attorneys are like, oh no, you have crypto, I'm not going to take your case. Because I have a friend right now who's going through something similar like that, trying to find an attorney, and everybody wants to stay back. But the younger attorneys, I think you have a great advantage if you put a little bit of headspace in there, because you will be able to help people, because it's coming and it's here to stay, I believe. It
is, and it's hard. Attorneys are very slow to adapt. The law itself is slow to adapt, so it just hasn't been addressed. So it'll just take some time to get caught up, but we will see the changeover and how we can help plan for that. Yeah,
because NFTs kind of go into that same category, which is going to be a very huge thing coming up. Do you know about NFTs?
Very little.
So that's another thing that could be brought up, because that you could do like property, for example, a home. You could put it into a digital asset and have micro investors into that property, so everybody gets to take advantage. So that'd be another piece that would need to go into your trust.
Correct. Yeah, you want everything to go into your estate plan. You want any asset that you have. Now, the only exception really is your retirement accounts. Because retirements are, as an IRA is an individual retirement account. It has to be tied to an individual, because if you put it in the trust, you're going to have to pay all the tax that's due, and we don't want to do that. So what you do is, depending on your marital situation and also what you're trying to accomplish, you can name spouse as primary beneficiary and trust as the backup beneficiary. Or if you're single, you could just name the trust as the only beneficiary of that account, and then it'll pay to the trust when you pass away.
So when the trust is your beneficiary?
Correct.
Oh, interesting. So if somebody had a life insurance policy, say, and they had $100,000, I'm going to just use me for an example. I have 2 children, and what if I pass away, and could I make the life insurance part of the trust, the beneficiary of the trust, and have the trust distribute, say, $10,000 a year to each child for so much time?
Correct. Yeah, you can. One of the beauties of the trust is you can put any restrictions you want on there. So yeah, you could definitely do that. You think about it, a lot of people, if they have minor kids, if you were to pass away while they're minors, do you want them to get $100,000 at age 18? Because that's the default. What the state will allow is, once they're 18, we figure you're an adult, so we're going to give you access to the money that your parents left you, unless you specify otherwise. And the joke is, how long does that money last?
Not long.
As long as it takes to get to the nearest car dealership.
Well, yeah. I have a trust fund baby. So she got hers at 21, and she got a lot of money. And it's not only, it's the money's one thing, but they appear like it rocks them to another core. They have no idea what to do with it. It can destroy their life. It can enhance their life, but it can also destroy their life, because people come in from the woodworks and everybody wants your money.
Yep.
So in Nevada, you can put it up till 21, 25.
There's no limit on how old you can put it on there. I have one client, they wanted their kids to work their whole life, and so they get nothing till they're 65. So it's their retirement account for them, essentially. So
okay.
Yeah, you can do whatever you want. You can say, another cool one I've done is we've been able to match it to what their tax return says. So if you're working and producing income and contributing to society, then we'll give you some distributions. We'll give you 50% of whatever you earned on your gross revenue for the year. But if you're not, or if you're just working part-time, coasting, not doing much, well, then the trust isn't going to help you there. But if you're putting in the effort, we'll double that effort essentially.
Oh, very creative. I'm the one that it would be rather have my kids have part of the money, so that as they go through life, because we all know life has struggles, maybe they need to get a hot water heater, so I would like for them to have little drips along the way. If they wanted to buy a car, then they could buy a car, or whatever the case may be. But that's interesting. Making them work till they're 65, that's tough.
It is. But there's also, they had to work their whole life as the philosophy, and so that's what made them successful. So they want their kids to have those experiences and have to struggle. Because one of the biggest things you see is, I had to work, or I want to give my kids everything I didn't have. And that's great that you want to do that, but by doing so, do you rob them of the ability to learn the skills that made you successful? And so finding that balance is really hard. What I always tell people when they're doing their planning is, don't try and, don't start with how much can I give them? It's how would you, if you were still around, how would you be giving this money to them? If they need it for a hot water heater, okay, yeah, make a provision in that says the trustee can have discretion to give additional gifts for, things like that, to maintain their standard of living, or to make sure they're not in poverty, or to down payment on a home, those kind of things. But try to make it the legacy of what would you do if you were here? What's important to you? Is it education? Great. So then let's set up something that says that if they go to school, pay for schooling 100%. Those kind of things.
Yeah, because I was thinking that my son goes to private school. So that would be something I would definitely put on the trust for my daughter, who's got 2 children. Like, I would like for her to be able to use that for the kids' education, especially here in Nevada.
Yeah.
Because Nevada, we got our education system's a little tough, so we prefer the private sector when it comes to that. And when you put the age limit of 18, say in a trust, can you change that at any time, or is it pretty much written in stone? It has to be when they're 18.
Well, so up until you pass away, this is what's called a living or a revocable trust. You can have that you can change that any time while you're living. And so, you come back and you say, all right, hey, I put age 40 initially, and now your kid's over 18. You realize, hey, they're smart. They got a good head on their shoulders. They could handle this kind of money. So I'm going to make it so that there is no age restriction on there. We can come back and do that. Now, once you pass away, there's no way to change that.
Okay.
But yeah, up until then, for sure, we can change any part of it.
Yeah, because whenever my daughter was going through hers, it was the trust was to be distributed amongst 12 grandchildren. And once the grandparent passed away, the daughter, my ex-husband's grandmother, went to go change it to up the age limit on the trust because she saw the falling out of the other grandchildren, and there was no way she could change it because of it was done and he was already passed away.
Now, there is a caveat to that. Nevada is considered the best state for estate planning, especially for trust laws. And so we have what's called a decanting statute. And just like you with the wine, you can take the assets of the trust and you pour it out into a different trust if certain requirements are met. So as long as the beneficiaries are the same, you can do that and change some of the age restrictions there. It's a difficult process, but it is an option.
Okay. So like right now, if I had a trust and I was going to sell my home, because your your home would be in your trust, correct?
Yep.
Do I have to jump through hoops because of that? Because it's in a trust when I go to sell it?
No, most people get, is that going to make it so I can't sell my home? But no, it's not, because the trust is an extension of you. The living trust is your social is the tax ID for that trust. And so all you're going to do when you go to sell that house is give the escrow company a copy of your trust. That's what they're going to ask for. And when you sign, you're not signing individually, you're signing you as trustee. So you might have to put TTE, after your signature every time. Other than that, there's no additional work or anything like that. Now, I will tell you, one of the common questions I get is people sell their house, escrow company sends them a check, and it says the trust name on there because that's who the seller was. But they haven't changed their trust or their checking account into their trust name, so they can't deposit that check yet.
Okay.
Now, it's not a big deal. You can convert your account to a trust account pretty simply, and that's ideally what you do when you set up the trust initially. But that's just a heads up. Go make sure all of your accounts are put in the trust name except for the IRA or 401k.
Okay, so because I have a friend who used to always write a check and then always had the trust on the very top of the check. So you only need, should that be your only bank account? The trust account?
It doesn't have to be your only bank account, but any bank account you have should be in the trust name, or at a minimum have the trust as the beneficiary on that account. I've got plenty of horror stories where, I have one couple, they, for some reason, were freaked out by the idea of putting the bank account, the checking account, in the trust name. They're like, well, we never keep more than $25,000 in there, which is what would go through probate. So, like, it's fine. We won't need it. We're not going to put it in the trust. We don't want to do that. I was like, okay, I advise you not to do that. Please put it in the trust. Just do it. Well, they both passed away within a couple months of each other. And it just so happened that mom passed away in January, and they had quite a few business interests, and those business interests paid them their yearly income from it in January, and it all went into just the checking account. And then mom passed away, and we ended up having to do a massive probate because all of those accounts or all those distributions were still in the checking account when she passed away, and we couldn't move them to the trust at that point. So we had to go open the probate and do all those added expenses because they had a hang up about putting the checking account in the trust name. And it doesn't change anything. I don't know why people have an issue with it. So I'm just here to tell you, having the account in your trust name does not change any aspect of your life. It doesn't change your taxes. It doesn't change how you write your checks or any of that stuff. It doesn't create additional work. Just do it. It makes life so much easier.
I wonder what their issue was with that. It's funny when you talk to people. I sell Medicare, right? And it's the same thing. Like some people just don't get certain things. It's just funny. I think they have the blockers in sometimes.
Yeah, they just have a hang up on, and they're not the only ones. I've had multiple clients, in the hundreds that have given me that issue before, and I'm like, why? There's nothing there. What's your issue? And I never can get an answer. They just don't want to do it.
It'd be something definitely to do a podcast about, for a topic to do a podcast about, right?
Yep.
Just to kind of see, maybe ask what the issues are. Interesting, very interesting. So, what made you decide to become an attorney?
Well, so my dad is an estate planning attorney, so I grew up around it. I was familiar with the industry, but I was more interested in finance and business and that kind of stuff. And I was all set to go work in New York to either be investment banking or day trader or something like that. And then I met my wife, and I just knew that lifestyle was not going to work for her. And so that's when I pivoted and decided, all right, maybe I'll go to law school. I saw the lifestyle my dad had. He was always at our sports and that kind of stuff. So that's how I kind of made that transition, and then came out of school and literally went to law school only to become an estate planning attorney. It's the only area of law that interests me.
Well, it goes with economics, though, if you like economics. So if you like economics, you should definitely be looking at the crypto space, right? Because it's definitely an interesting topic.
It is.
So so you have trust, attorney, and then estate planning. What is estate planning? So
estate planning is the broad umbrella that plans all aspects of your, essentially your financial life. And then the trust is one tool we use within that. And so I work a lot with financial planners. I work a lot with CPAs, and we're kind of your team to make sure that everything we're doing works together. So when I put together a plan, are we worried about charitable giving? Or do you have a business that we need to make sure is structured correctly from a liability side and from a tax side? And so I talk with those people that your team, your financial advisor and your CPA a lot to make sure that we're all working together, because that estate plan encompasses all of that.
Okay. So when should someone start estate planning?
That is a good question. The minimum for doing a trust is you need to own a home.
Okay.
Because if you own real property in the state of Nevada, then you have to do a trust, because the laws here for probate said if it's over $25,000 of value or any real property. So you can only have $5 of equity or even negative equity in your home, which a lot of people have had in the past. It doesn't matter. You still have to go get probate court approval to get that to the right person. Once you've hit one of those two triggers, the over 25,000 or the real estate. And so that's why I say if you own a home, you need to have a trust. And usually if you can afford a home, you can afford to do your planning as well.
Sure.
The other one is if you have young kids, even if you don't own a home and you don't want, you have any sort of life insurance that's going to pay out and you don't want your kids to get that money at 18, that's when you want to start looking at planning so you can tier that distribution so it's not all at once as soon as they turn 18.
Well, can someone get insurance if they're not 18?
Yeah, you can get life insurance on kids as soon as they're born.
No. I know you can get it when they're born,
mm-hmm.
but I mean, are children allowed? Like, say if I pass away
mm-hmm.
and my life insurance goes to my son and he's only 13.
Oh no,
he doesn't get that.
No, it's either has to be in a trust account for them, like that you set up, or it's called an UTMA account, a Uniform Trust Act for Minors account, and somebody has to be designated as the guardian. But as soon as they turn 18, that account has to be transferred to them. Yeah,
because we're doing that right now with our son, because we are suing somebody and on his behalf.
Mm-hmm.
And that was one of the things we have to set up is everything has to go into his name.
Yep.
When we set it up. So that'll be good for him. Maybe he'll get himself a new car when he graduates high school. So really, whenever somebody buys their first home is probably when you should start really looking at planning a trust.
You really should look at planning. And the nice thing is this is called a living trust. It's called an estate plan. It's not just a death planning. So it can change. We plan for those changes, and we want to make sure this is updated regularly just based on what your needs are. So I try to meet with my clients every 3 to 5 years just to make sure that whatever is going on, whether they had significant asset changes, they had another kid, or, they don't like who they named as the guardian for their kids or who is in charge of their trust, that we can get all that changed and updated. Because if we don't, then, it's going to be whatever your last thing that you implemented. Well, that's what stands.
Right. So when you say if we did a trust in Nevada and then we were moving out of state, you need to have a trust in that state, correct?
Not necessarily. If you've already done a trust in one state, you don't have to do it in the new state. It's valid in all 50 states when you set it up.
Okay.
Now, the things you want to look at is, like I said, Nevada is one of the best states for trust planning. And so we want to look at, based on what you're trying to accomplish, is Nevada a better state to have that trust registered under? And not really registered, that's the wrong word, because there's no registration with the state or anything like that. But the governing law of that trust is Nevada. And so that would be, it's just one of those things where you do it on a case-by-case basis. You don't have to move to a new state, redo everything just because you moved there. If you had just set up your trust a year before, it doesn't make sense to do that. And so it's just one of those things where we look at it and say, does this make sense or does it not?
So is Nevada one of the best states because of no state taxes?
So that's part of it, but it's more of the trust law itself. We have some great attorneys who've advocated at the state level and got the laws. So from an asset protection standpoint, especially on the irrevocable trusts, we are the best. And so as far as, we give the most protection with the least amount of waiting time, and we have court cases to back it up as well.
Okay. Very interesting. So you don't want a will, that's for sure, because that'll put you in probate, correct?
Well, so even with all of our clients, even if we do the trust, we do a will as well. The will serves as a backup. At that point, we call it a pour-over will. It just says, hey, judge, if we go to court for any reason, put it all back in my trust and let the trust govern and distribute it. We don't want you to get involved in that part of it. So, ideally, we don't want one. We don't have to use it, but we have it just in case.
Okay, which is you want the judge not to look at the will because that's what incurs all those fees.
Yep.
Right? You want it to go back to the trust.
Even with that, you're going to have all those fees for anything that's left out, like that one situation I was talking about with the checking account. We still had to incur the fees, but it's only on that one asset that was left out. It's not on your entire estate.
Okay. And then, so you also would do a power of attorney and a living will and a healthcare directive inside of that as well.
Yeah, that's part of the basic estate plan. That's our building block as we start with those things. You want to have the power of attorney, so if you become incapacitated, who can sign documents for you, pay your bills, those kind of things. And then, we definitely want a healthcare power of attorney so that, if you're in a hospital, who gets to make those decisions, who gets to pull the plug, that kind of stuff.
Okay. So the power of attorney, once you set that up and say somebody goes into the hospital and they're in a coma, is that where the power of attorney kicks over?
Well, so you can do it. You can do it general, meaning that from the second you sign it, you give the person the ability to sign whether you're in a coma or not. Or you can do a springing one, which would be, if 2 doctors declare you incompetent, then the power kicks in. So it's just a matter of how you want to set that up.
Well, you got to really trust your power of attorney.
Yeah. If you're not going to have it springing, you definitely got to trust that person.
Yeah, because they could essentially wipe out your whole account.
Yep.
Okay. I just want to make sure I was correct on that.
Now, they do have a fiduciary duty to do what's in your best interest.
Sure.
But, if the money's gone and they're, halfway around the world, good luck catching up with it.
Exactly. Interesting. So what is a healthcare directive? For those that may not know what that is.
So there's really kind of 2 documents in Nevada. We have a directive to physicians, or sometimes referred to as a living will. And that's just kind of the basic, hey, pull the plug or don't, or either I want to be on a feeding tube or don't put me on a feeding tube. And then you have the more detailed healthcare power of attorney, and that goes into the details of, if I'm in a coma, yes or no, pull the plug. If I have a terminal condition, yes or no, pull the plug. Or I just want my life prolonged no matter what. And then you can also specify in there your DNR, if you want to do that as well. We have those 2 documents here in Nevada. Like if in Utah, I also practice there. Utah, they've rolled it all into one document. So that one is a very state-specific thing. And if you move to a different state, even if you had your planning done, you definitely want to get your healthcare documents updated in the new state.
So what is besides the financial part of doing a trust, what is the other important lesson to learn when it comes to trust planning?
There's many. I would say knowing who to put in charge and then the restrictions you want to put on there, the legacy aspect that I talked about earlier, making sure that what you want, what's important to you is what is conveyed through your money. But also, make your family aware of what you're doing. That
was going to be my next question.
Because I can't tell you how many times, I don't know what it is. It's a generational thing where we want to hide stuff from our kids, hide stuff from the people that are going to be getting it, and then just have it be a surprise at the end. And so they don't know what's going on, especially if one kid's disinherited or one kid's getting more than the other, and there's no explanation as to why. That's where all the fights start coming in. But if you can lay it out ahead of time and say, hey, let's do a family gathering. And I've done this for multiple clients where they bring them into my office and say, all right, this is Blake. This is our plan. This is what's going to happen. And Blake, here, tell us what's going on, how they're going to do it, and whatnot. So we walk through the steps. Hey, this is the distribution. This is how it's going to be divided. This is how you're going to run it, and what you need to do, should anything happen to mom and dad. And every time we've done that, I've never had an issue with a fight because it's very clear. Hey, mom and dad did this. We were all in the room. They said it themselves. It was verified by the attorney, and so on. It's when I get the call from the kid who was disinherited or only got $10,000. Everybody else got $5 million. Hey, why is this? I'm suing you because, this XYZ. And I'm like, sorry, that's just what your parents did. They didn't give me an explanation. That's what they wanted to do. So even if you do that meeting, I would still put it in writing as a handwritten note to your kids to say, hey, here's what we're doing. Here's what we're trying to accomplish, and save those fights from happening.
So the one kid that only gets $10,000 compared to the $5 million, he could sue, but his chances are pretty slim.
He would have to prove something to the effect of there was doctor's notes saying they were incapacitated when they executed those documents, or that the other kids were putting them under duress or threatening them, something like that.
Which is very hard to prove.
The other thing is, within the documents, it always says, hey, if you challenge this and you lose, you only get $1. So he's going to lose at least his $10,000. So he's got to put something on the line.
Well, at least $9,999.
So that's why you'll see that where, we're going to leave the kid $1,000 or $10,000 so they have something meaningful to lose, so that if they do challenge, they lose out on that, and it's kind of deters them even more from challenging it.
Oh yeah, because if that person in that kind of mindset, that $10,000 is a lot of money for them, even though it's not.
Yeah,
it's a lot of money. Yeah, I just had a friend who inherited $1 million, and it's interesting to watch how she's going through the process of spending it. So I don't know if she's got an estate planner and a trust attorney, but that probably would have been my very first thing to do, inheriting that kind of money. That's what I would have done. Like everybody says, what would you do if you won $1 million in a lottery? I would consult my attorney and my CPA would be my very first two things I would do.
And then a financial advisor.
Exactly. Who likes crypto? Who likes crypto?
And there are some out there. So it's finding the one who works for you. Not everybody's right for everybody. That's what I tell people too. I'm not the right attorney for everybody. Some people want a female. Some people want an older person with more experience. Now I'm to the point where I'm not just the young guy anymore. So somebody fresher than me. So you got to find someone who's going to communicate with you well, that resonates with what you're trying to do and all of that as well.
Well, that, and you have your father.
Mm-hmm.
So he's been in the business for a long time. So that's probably your person you go to, right? If you have a question to ask, maybe you should interview him on your podcast. That'd make a great interview.
Yeah, if he could figure it out.
Is he here in Las Vegas?
No, he's in St. George.
Is he? So St. George is a nice city. For those of you that don't know where that is, it's in Utah. It's right across the border from Nevada. So is there anything you'd like to add before we sign off today?
I would just say don't be afraid of doing the planning. It's probably more affordable than you'd think, and most attorneys do a free consultation. So you can sit down with them, interview them, make sure it's the right fit, make sure they're actually going to take the time to do it. There's also a lot of online stuff out there right now. You have your LegalZooms and Rocket Lawyers, and then there's a few other ones, Trust and Will, Estate Guru, those kind of things. So it's just, and I don't like talking bad about those because some of those can be pretty good, but I will say going to an actual attorney who's going to be able to sit down and go through and make a customized document based on what your needs are is going to be better suited for you, and it's worth the money. Because one of my jokes I always say is, hey, you can pay me a little now, or you can pay me a lot later.
It's up to you.
It's up to you. So, from a probate standpoint, I would much rather do a probate. I make way more money doing that. But I hate it from, an emotional standpoint, dealing with the family and seeing that, they have enough to grieve with from, whoever passed and what's going on. And then to have that drag out for the next year, it's not fun. It's the least favorite part of my job, is having to call the family, hey, here's the update on this. Remember how mom died and didn't plan, and here's where we're at with all that. Whereas, I get to the point where if somebody passes with a trust, I call them, hey, just give me a death certificate. Boom, here's the money. You got it all. Go for it. Here's what the plan is, and call me if you have questions.
Yeah, and a lot of fighting will commence in that year's time. A lot of hurt feelings.
Yeah.
Families can be broken in that time. My grandfather, when he passed away, he had 3 children. And my mom, he didn't pass away yet. My aunt had passed away, one of the 3 children. And mom and my uncle sat down with my grandfather and said, how did you want to distribute the money for your house, which wasn't much? Do you want us to split it with Hope's 3 kids, or do you want us just to split it? And he said, I just want the 2 adults to split it. Well, he never changed anything. So what happens when he passed away? It had to go to my mom.
A third.
Yep. And then the other bit to my cousins. So, but it happens. I mean, we all think we have more time on this earth than we have, but you never know. I mean, something could happen to us today. Who knows?
If COVID has taught us anything, it's that we're not we're not going to live forever, and so get your planning done now, because you never know what's going to happen, and and then it can always be updated. Something now is better than nothing later.
Oh, I love that. That's a great, something now is better than nothing later. I love that. So you can get a hold of Blake at 702-616-6001. Again, he is here in Las Vegas. He's at 6980 South Cimarron Road, Suite 110, and the zip code there is 89113. And we want to thank Blake for being on our show today. And this is Ann Severs signing off with Senior Aspects. Thank you and have a great day.
Thank you, Ann.
Thank you.
Thank you for listening to Senior Aspects, where each week we talk about the issues that affect our world. For more information about this show, please go to senioraspects.com or allaspectsradionetwork.com. Thank you and have a fabulous senior week.